prescription is a street drug. Xylazine is not 3306. So we have two issues with Mr. McGrath's case. One is the same as Luann Burgess. I've got 3306 drugs on the list that impair. I've got some off the list that clearly impair. What do you do with that? How do you present it? Because the law does not let us care about those non-3306 drugs. And the bigger concern, or the bigger picture on at least this case, law enforcement hands were tied the night before because they couldn't arrest him for an 1192. Had them been able to do that, Michael Clank would be here. His parents would not be walking around devastated and shells of their former selves. But I can't even begin to put into words what his grandfather thinks, since he's the one that gave Michael the car that he was in and loved so much that ended up being what he died. He actually died 2 days later in the hospital, but in essence. So my question for all the members of the legislature, Senate and Assembly who are not supportive of this movement is, why should it matter if the substance is or is not on 3306? Why can't a driver be charged? If you're impaired, you're impaired. The Clinkies, the Humes, the Lansings, the Pelosi families, they don't care. Their loved ones were not at the Thanksgiving table. They will not be at holiday for Christmas, for Hanukkah, for all those other celebrations. And if you were to ask any one of them or any one of our victim advocates here today, who again, they keep coming to the table hoping that this is the day, that putting their raw grief in front of strangers to get the point across will actually have that happen. I don't know what it takes. And to hear the what if, the what if, the what ifs, without any data that backs it up is incredibly frustrating and I think very offensive to our victims, and is just setting us up to have more victims. It's time to get it done. It's time, 20 years is beyond enough time to get this done and be able to have law enforcement do their job, prosecutors do their job, and actually give victims some sense of justice, because it's just not there today. I could go on and on, but I won't. I thank you for your time, and I thank you for moving this forward. It's got to get done. Without it, we're just going to have more deaths on our roadway that are just not necessary. Happy to take any questions.
I guess not really a question, because I don't know if there's a question you wouldn't agree with me. I just want to say thank you for obviously telling the stories. I said it before, the stories hearing continues to motivate, is a motivator for me to push this bill forward. And I just want to thank you for that. It's impactful, and we need to get rid of a list, plain and simple. So I just want to say thank you.
Well, thank you. And those families, they do motivate, right? I mean, that's what I think has motivated every prosecutor in this room. It certainly motivated me for the 20 years that I was doing that. And in fact, it motivated me to come to DMV, to take it to the statewide level, to get these changes made. I was very happy to see the governor put it into her budget bill last year. Unfortunately, it didn't, get passed, but there has been movement, and it just shows this is the time. This is the time that we needed to get it done. So thank you.
Mary, thank you. Hey, It's our pleasure to welcome Jeff Kimelman, Bronx District Attorney's Office, Chief of the Vehicular Crimes Unit. Thanks for joining us today.
Thank you so much. Thank you, our legislators, for having me here today. To my colleagues, our elected DAs, members of the general public, victims and their loved ones. As you said, my name is Jeffrey Kimelman. I'm the Chief of Vehicular Crimes at the Bronx County District Attorney's Office. DA Clark was unavailable to attend today's symposium. However, she has been a long-standing supporter of this legislation, and she sent me to deliver remarks on behalf of the office in her stead. I want to thank you for the opportunity to testify on behalf of the Bronx District Attorney's Office on this issue and in support of victims of drug driving, and so that they can obtain justice. In 2016, when DA Clark took office, she came in with a vision of creating a 21st century prosecution model, which included creating new units and bureaus to target specific crime areas and enhance existing ones. The Vehicular Crimes Unit is specifically dedicated to prosecuting and overseeing all vehicular crimes. This includes DWI cases, aggravated unlicensed operation, 511 cases, reckless driving, leaving the scene cases, and all the way up to vehicular assaults and vehicular homicides. And those are the cases that I'm charged with overseeing. Additionally, I have 4 trial preparation assistants or paralegals who assist in collecting, gathering, and providing discovery, as well as assisting the ADAs throughout the office in preparing grand jury presentations, hearings, and trial in all facets of litigation. DA Clark recognizes the need for dedicated staff to prosecute these specified offenses, and she's dedicated resources to this effort. Now let's talk about the proposed legislation. This would amend the vehicle and traffic law to allow us to prosecute cases of driving while being impaired by all impairing drugs. Currently, as we've heard, New York is only one of 4 states left that requires a drug to be listed in statute to trigger a drug driving violation. Therefore, unless the drug driver admits to driving while under the influence of a controlled substance or consents to a drug test, which identifies a drug that happens to be listed in Public Health Law 3306, we can't obtain justice for the victim and we can't protect our roadways. We need legislative change in order to protect New Yorkers from drug drivers on our streets. The proposed legislation would close these deadly driving loopholes by amending the definition of intoxication and impairment, according to the proposed bill, to now include any substance or combination of substances that render the driver incapable of operating a motor vehicle. In doing so, New York moves towards the greater majority of states that understand synthetic drugs are more predominant, as we've heard, than when the current law was drafted, and because of their ever-evolving chemistry, they cannot be captured on the public health law statutory list of controlled substances, as required under our existing law. Moreover, there have been some confusion in courts by not having clearly codified definitions of impaired and intoxicated, and it has led to uncertainty in our prosecutions of drug driving cases. And that's, it's hit the appellate courts on different levels now, where some courts are talking about intoxication with regards to drug driving cases, and some courts most recently are saying, no, it's the impaired standard. The proposed legislation would remedy that confusion, providing the distinct meanings for each category. Additionally, the legislation would allow and add oral and bodily fluid testing to the roadside screening tools. This is similar to like a PDT, which is given to drivers who are alleged to have driven while under the influence of alcohol. And this will assist police officers to determine if the driver has taken drugs before getting behind the wheel. Oral fluid testing is not new. It's allowed in over 20 states already, and it helps to both the establishment of probable cause, which is important, but also potentially can exonerate people who are not driving while impaired. To be clear, testing alone does not prove impairment. Rather, it assists in the investigation. It's one piece of evidence towards the requisite proof overall of and the proposed legislation merely authorizes modern best evidence testing procedures to now be utilized in New York. And I've seen this time and again in our cases, when you have the alcohol cases and the officers have a PBT, it can give that officer that confidence that they are accurate when they decided that someone was driving while intoxicated by alcohol. Why should the officers not have the same tools available to them when they suspect someone is under the influence of an impairing drug? It's very common sense legislation to require the oral roadside fluid testing. Furthermore, the legislation explicitly restores the provision of the law that refusal to submit to a breath test, and now includes refusal to submit to an oral or bodily fluid test, as a traffic infraction. The charge, which had been permitted under the present statute as a consequence for violating the mandatory public safety provision, has been invalidated in recent court decisions, and effectively doesn't really have any application anymore in practice. The proposed legislation brings back New York's rules of the road consequencing for refusing to take that roadside test. And that will be significant when a driver has to make that decision, and will encourage them to do so that we can learn whether or not they're under the influence of an impairing drug. Likewise, and importantly, the legislation automatically suspends a drug driver's license pending prosecution, the same as a drunk driver. Under the current law, a drug driver can be arraigned and leave court miraculously with a valid driver's license for the pendency of the case. Until the case is concluded. The proposed legislation creates parity in the process between our drug drivers and our drug drivers. I can't tell you how many ADAs under my purview are just shocked that they call me for arraignments. Why can't I ask for the defendant's license to be suspended? He was passed out with a light cycling for 10 minutes, and they suspect he's under the influence of heroin. And I say, because the law does not allow you to do so. You have to follow the law. And that's what you're stuck with. Now, this person who drove in this manner, which we may or may not be able to even prove the case in and of itself, is now allowed to continue to drive, which is very concerning, especially prior to them obtaining any plea or getting any treatment that they need to ensure that they are driving safely on the roadway amongst everyone else. We'll talk a little bit about Bronx cases. In the Bronx in May 2024, in support of the legislation, I was in attendance. DA Tierney was there, DA Katz was there, and of course DA Clark, who spoke passionately about this issue. DA Clark is a zealous advocate for this legislation because it would impact real Bronx victims and their families, two of which were in attendance at the rally. And you heard from someone at the press conference, Fajol Chowdhury, who was here today, and he was also at the rally on that day. So let me tell you about two of those cases that relate to deadly driving. We're calling this a deadly driving bill. So there's two deadly driving cases. September 2021, Karina Lopez of the Bronx. Unfortunately, her family couldn't be here today, but they were at the rally in 2024 in support of this legislation. She was on her way home to meet her family for dinner. At the same time, Robert Johnson came speeding down a bike lane in his pickup truck. She was literally trying to get something out of the passenger seat of her car, in the rear of the passenger seat that was roadside, and he obliterated her. It was one of the worst videos I've ever seen in my 17 years in the DA's office. And he went on to strike 12, it took 12 parked cars for his car to stop. Should have showed that video too, I should have brought it. Our office was able to charge Mr. Johnson and secure a conviction, but only because he admitted to the cocaine use prior to driving and consented to giving his blood to the IDTU officer. Because you also need to meet a certain standard to get a quarter of the blood draw. So his admissions, his consent to the blood draw made the prosecution easier. However, without that, we would have had difficulty in getting justice for Karina, given the loopholes in the drug driving laws. In fact, Karina Lopez's family spoke at the press conference how they wished that he could have been stopped before killing their daughter and sister. Yet, meaning his car could have been stopped and he could have been stopped on another date. And that was one thing that they wanted. And had he been stopped and we had this oral fluid testing in existence, perhaps it could have been prevented. Perhaps he could have been treated on another date. Another Bronxite whose life was cut short due to deadly driving is Mohammed Rahman. Mohammed was killed in September of 2023 while crossing the street on his way to mosque to pray. At the same time, Victor Ramos was speeding down the street with a suspended license after smoking marijuana. Mr. Ramos' car slammed into Muhammad while going almost twice the speed limit and propelled his body into the air. He almost looked mannequin-like on the video. He landed on the ground and was killed instantly. In this case, too, the defendant admitted to smoking a blunt. I remember the body-worn camera. It was almost as if he didn't realize that he was doing something wrong, which is a whole different issue about education and on this issue and getting the word out about marijuana use and driving. But I remember watching the video, it was almost like all I did was smoke a blunt. And he got behind the wheel. He ultimately consented to being examined by a drug recognition expert. And I know it came up earlier, and I've consulted with the NYPD technical supervisor. There are 13 in New York City. And there were no ramifications for refusing to submit to a DRE. And further, and this is not written here, but I think it's important to note, the only drug that they can potentially identify clearly is cannabis. All the other drugs, they can only give you a general category, assuming that a defendant consents to a test that is voluntary, that has no ramification statutorily if they refuse to do so. But if he didn't consent to that test, we'd have to go by his word. That's a hard case to prove in front of a jury, especially because the evidence of the marijuana ingestion is not always just sitting right there in the car for you to gather. You know, it's not shocking to believe that people ingest, the same way they drink alcohol, they ingest drugs at home or at a restaurant or at a bar or at a friend's house or at a club, and they don't bring the drugs or alcohol with them, making it more challenging for us to inferentially prove, because that's what we're stuck with at this point. We have to ask jurors to infer that the drug that was ultimately found in the car, if we don't have a blood test result, is the drug that was ingested. Based upon, so we're piecing things together by inference because that's the best we can do for victims of these crimes, and that's not enough. You know, Muhammad, you heard from Badr, father of 7, grandfather of 18. Their advocacy to change this law has been amazing, and I'm really appreciative. I think Badr might have left, but the appreciation and working with families like his is what keeps me doing this job. And I really just, my heart goes out to him and his family and all the other victims of these crimes. It is for them and the thousands of cases that we cannot prosecute because of the drug driving law loopholes that we advocate for legislative change. Time and time again, we dismiss these cases due to the requirement to name the drug, when there is no mechanism or legal requirement in place to assist law enforcement to learn the name of the drug. Many times, even if the drug is known, it may not be on the current list, and we've heard this. Currently, the Bronx DA's office, this was as of about 2 weeks ago, has only 12 active DWIs drugs cases, out of approximately 420 active DWI cases. So if you're just looking statistically, something doesn't add up. And it's not due to the lack of drug driving, but rather it's directly correlated with the difficulties that law enforcement has with obtaining evidence sufficient to arrest someone for DWI drugs, and our office's ability to prosecute these cases. Lastly, and another reason that it's important to pass this law now, is that among the younger generations, we're talking Gen Z and millennials, and recent articles have talked about this, alcohol consumption is on the decline, and cannabis consumption is on the rise. Research shows that the share of adults under the age of 35 who say they ever drink has dropped 10 percentage points in the past 2 decades, going from 72% in 2001 to 2003 to 62% in 2021 to 2023. At the same time, cannabis use in 2024 has reached the highest levels ever recorded among young people. With daily use significantly increased, it was 7.1% in 2014, it's now 10.8% in 2024. That is high. There are various possible reasons to account for these trends, such as cannabis became legalized in nearly half of the U.S. states, including here in New York in 2021. And younger generations are much more interested in living healthy lifestyles, perhaps, than generations past. But whatever the reason is, the reality must be accounted for and addressed in the evolving legal and fact landscape. the supporters of the legislation, especially both of you, Senator Ryan, Assemblymember Stern, for your advocacy in stopping deadly driving. I want to thank my DA, Darcel Clark, for her passion to pursue justice with integrity and allowing me to share my perspective here today. Thank you all.
Thank you. You can speak to anybody along the chain, whether it is alcohol producers, wholesalers, retailers, the bar and restaurant industry, and everybody will say the same thing, that alcohol is way down and the drug use is way up. And it's interesting, just the other day I was having a conversation with barkeepers in the vicinity of Madison Square Garden, and that the patrons would come and used to spend an hour there and probably get 3 or 4 rounds before going into the garden to watch a Knicks game. They don't do that anymore. They come in, they'll have one drink, and they'll see them, hit the gummies, and then go to the game. And so it's, again, my question to you would be, first of all, the numbers on drug driving versus drunk driving are very compelling out of your office, and I think that's something that I'm certainly looking forward to highlighting with my colleagues when I go back to Albany. So I look forward to reviewing the numbers again. But yes, a lot of different reasons why that's the case. But yes, my question is within the office of the Bronx District Attorney, knowing that that's where the shift is, what, if anything, have you needed to do in order to make that shift? Certainly, a legislative change here would be most helpful to you. But before that day comes, and hopefully it's very soon, I'm wondering how have you and your team have reacted to that in terms of how you look forward to prosecuting these cases? It has to be a tremendous challenge.
It's such a significant challenge, and I was referencing inferences, and you're ultimately dealing with multiple pieces of circumstantial evidence and hoping and praying that the DAs who are assigned to these cases, while doing their discovery obligations and handling 100+ cases, have the time to go through the body-worn camera and identify a moment where a defendant potentially makes an admission. You're seeking admissions, you're seeking to find any evidence of drug usage in the car, whether it's the drug itself or some sort of paraphernalia or some indicator that the defendant actually ingested the drug. Because otherwise you just have an officer giving observations of that which they believe mirrors impairment. And the defendants very quickly consent to the Intoxilizer 9000, where they blow triple zeros. And then the moment that the DRE shows up, they refuse. And they also refuse the urine. And so you're left with no DRE, no urine. Maybe they'll have a ramification for the license for the refusal to the urine, but ultimately the case is going to get dismissed. A lot of times we'll have, what we'll do is if there's a 220-03, we can charge the possession of a controlled substance. We'll prosecute that to the best we can, or many times someone also happens to have a suspended license, so those charges will stand and will not be able to prosecute the driving while impaired by drugs charge. So sometimes these cases won't even go down as a dismissal because we'll find other ways to plead out and do our best to try to incorporate drug programming and things like that into other charges, assuming that that's not the only charge that lies for that criminal transaction. But, so that's how, so you hear the number 12, and I'm sure there are more cases than that where I'm describing where we've done these types of things to address the concern, because at the end of the day, if someone's walking out there and their license is valid and they got away with drug driving, we're not protecting the public. And so what I'm tasked with is educating the office and making sure that we do every last thing we can in terms of uncovering every stone like we do in every case to make sure that if we can make the charge stick legally, we do.
We heard the number before that there are 420 DWIs statewide. Any idea how many operate?
No, 420 DWI cases. Oh, no, there are also, yes, there are 420 statewide. I'm sorry, yes.
Any idea how many operate in Bronx County?
There's 13 that we share amongst the 5 boroughs. So they're available 24/7. They're not going to give you, and I don't want to speak on behalf of YPD, but they don't give you roadside DRE testing, it's generally at either the hospital if necessary or the precinct that's designated for DWI testing. So that's why the oral roadside fluid collection is critical, because you're not going to get a lot of DREs on scene. It's just not going to happen. Most of the time in a city this large, with so many officers on patrol, it's generally patrol cops who do not have this training, who are going to be making these arrests, and they are not DRE qualified. And so we're relying, I mean, and many times the observations are so obvious. Someone is under the influence of something, and they are significant. The impairment is right in front of your face, and they can't figure it out. And the person's not giving it up to them. And that person should not just be, given a summons and sent down their way. They can't. Like I said, I can't count the number of cases where the foot is on the brake, the car is in drive, and the light is just cycling while the person is literally passed out. I watched the case. I did a suppression hearing the other day where it took 8 minutes of knocking on the window, and ultimately they had to break open the car window to get a drug driver to wake up. Literally, I did that hearing the other day, criminal court in Bronx County. Thankfully, and I don't know how the prosecution is going to go, and I don't want to speak too much about an active case, but that was a tough case, and it was admissions by the defendant and that we were going to use that hopefully will carry the day for the prosecution, because ultimately he refused to provide us with a urine sample.
Thank you. Okay. Just quickly, not for now, but I would like to have a secondary conversation, perhaps a follow-up. I want to talk to you a little bit about threshold for securing a court order and some other mechanical questions, but I'll follow up with you, or DA, whichever works better. But I guess the question is, I know the answer to the question basically spoken. He says a lot of alcohol consumption on the decline and substances that are not identifiable we can't prosecute for. And we've heard that a lot from Suffolk County vehicle. Would you agree with his PowerPoint, Tierney's statements that these drug driving or drug on whatever substance is becoming much, much more common than it is alcohol? And how big of a problem is it for the Bronx County?
I want to take my time to be thoughtful about the response. It's a good question. There is a level of proving the negative, because a lot of times I don't learn of the way our office is structured is that when the case, if an arrest is made and it comes to our ECAB, or our Early Case Assessment Bureau, there's a decision made, and they know the law, because I've explained it to them, and they've learned it. They'll decline to prosecute the case if we can't prove it, and I may never learn of that. So it's hard for me to quantify it, although they sometimes will call me and reach out to confirm, because they're very nervous about declining to prosecute the DWI drugs case. So but the list is always of the ultimate concern.
Yeah, prove the negative, we heard that, but is it the opinion of the Bronx District Attorney's Office that hundreds and hundreds and hundreds of people are being not able to be prosecuted under the current statute?
I don't know if I can statistically give that to you. I can give you the day-to-day over the course of the last 5 years that I've held this position, that the number definitely is over 100, definitely hundreds of cases over the course of many years that have come in, and either we were able to commence the prosecution, but ultimately the case was dismissed, or we had to dismiss it, or we had to go forward on a different charge, not the 1192 sub 4. So, those are all different categories, whether it was the decline to prosecute, a dismissal, or pleading it out to a different charge. So those are different buckets of cases, I would say, but it definitely is in the hundreds.
Thank you, and I look forward to the follow-up.
Thank you.
Thank you.
Thank you to the It's our pleasure to invite up Andrea and Timothy Carpenter.
Christopher Guzman was a repeat offender. He was 39 years old and had been using drugs for years. He had a history. The absolutely insane thing is that even if he had been pulled over just a block before the crash, unless the police could name the specific drug he was on, and the drug was on the specific list, he would have walked. And something even more insane is when we were preparing for the trial, the first drug test that he was given by the police was going to be thrown out of evidence because the police officer did not know what drug he was on. He was on fentanyl, which we found out when the hospital did the blood test because he OD'd and had to be Narcan. How is that for a kick in the gut? This is unacceptable. The laws need to change. All drug drivers need to be held accountable. I'm not going to speak about the specifics of the law and what drugs are and aren't on the list. There should not be a list. There isn't one in 46 other states. But I will leave those details to the experts, and the experts have done a very good job explaining it. Here's the thing. You never think something like this will happen to you. You can do all the right things. You can raise your children to know right from wrong, to not drink and drive, to not do drugs. You can be the most cautious driver out there. You can follow all the rules and all the laws. But now look at us. My brother-in-law was in the right lane, driving below the speed limit. Yet Christopher Guzman, who had enough fentanyl in his system to kill a normal person, found my son and murdered him. We never got justice for Timothy. This killer was supposed to be in rehab during the trial, but he overdosed again, and this time there was no Narcan to save him. Timothy was the best son we could have ever had. He was so smart and funny and handsome and kind. He just lit up the room when he walked in, made everyone smile. He was the type of person who would help anyone, and now he's gone forever. I can't fully describe how it feels to sit in a hospital room with your dead child. The shock, the disbelief, the agony, the soul-shattering pain right here, the pain that never goes away. And then later the anger that your child's death was caused by the selfish decision of a drugged driver. All drug drivers need to be held accountable. We need to give the police the tools they need to be able to keep these people off the roads. Let's do the right thing and make the road safer for everyone. It won't bring back Timothy, but it might save someone in your family. Thank you.
Our next speaker is going to be virtual. So we're going to have just a very short break, a few minutes while we set that up. But I want you to know that in the audience from Responsibility.org is Chuck DeWies, and he has a Sotoxa oral fluid, roadside oral fluid device if you'd like to see it. I don't know where you're going to do that, Chuck, but you're going to go in the other room, you're going to do it here, I don't care. Okay, just a couple of minutes just so we can get set up, because we're running behind. I know you know that. Thank you very much. David Hall, you're going to hear from. And Joey Zimmerman, you're going to hear from. They are two of the three men that were working their regular job and had no way of knowing that this was going to be what happened to them and what happened to their lives. Fortunately, all three survived. But Brian was not able to be on. He's the third of the DOT workers. But you need to know a little bit about this. This is a case being prosecuted in Steuben County, upstate. DA Brooks Baker, and I'm very grateful to him for his help and cooperation. He had received this video in the discovery process, and it is now public. It had not been until the indictment was filed. What he told me, DA Baker, from the scene of this crash back in June, because I was on the phone with him, it was the day before the last day of the legislative session, June 11th. June 11th. And the bill to make nitrous oxide one of the things that would be covered as being, doesn't matter whether it's on the list, sat unvoted. I contacted the Civil Service Employees Association President, Mary Sullivan, and she got on the phone with me, which stunned me actually, but she was outraged. She was hurt on behalf of her workers, that this is what they have to face, and that if this woman who struck these men had been stopped a block before that crash, he could not have been arrested because she was on nitrous oxide and is not on the list. The evidence at the time, I need to tell you that these are all just allegations though, because she is not yet convicted. But I believe that they have strong evidence and hope, of course, that justice will be done. At the time, DA Baker told me that she had just left what they call a head shop in upstate and legally purchased nitrous oxide, and within minutes of that purchase, what you just witnessed occurred. She was clearly impaired. She did not know what was going on when she was at the scene. And at this point, I'm going to ask David Hall. David, I'm sorry if you saw that for the first time now. I tried to warn you. Would you please convey to the audience and to the legislators who are supporting the bill your experiences from that day?
Good afternoon. Can you hear me?
Yes, sir.
Good afternoon. I am David Hall. I am the supervisor of that bridge crew, and that was me that was talking with my supervisor at the time on the phone when I was struck in the back. It has been life-changing, life-altering. You never want to see your guys go through that, especially yourself. That is the first time I've seen that video, and I just hope we can learn from it and make some changes that need to be made. I feel terrible for my crew that deal with the consequences of that every day, as I am still dealing with them. I still have multiple surgeries ahead of me. I am still off work, and it's like I said, been life-changing. You think about things like that when you go out on the road, and I have been a supervisor now for 11 years, and one of the things when the guys come to you and talk about how do you do it, I mean, you gotta put it out of your mind, or you won't get nothing done out there when you're on I-86 appreciate that, but it doesn't change the fact that, you know, I'm a single father of a 17-year-old daughter that she could have lost everything that day. Had we been closer to the truck that she rear-ended, you know, or in direct line, she could have killed all three of us. It's just things that you think about every day. Something needs to be done. You know, she's been caught before and just released with no consequences. It's heartbreaking. I feel terrible for my other, you know, guys on my crew that have to deal with this and think about this every day when they go out on the road. Thank you.
Thank you, Mr. Hall. Is Joey Zimmerman available? He should be the other Zoom person. Hang in there, Mr. Hall. Thank you for being willing to do this today. It's above and beyond, but you're going to save lives. I believe it. Same as Timmy and Andrea Carpenter. And Joel Chowdhury, who had to leave before we got to it. Are we ready to go, Mr. Zimmerman? Okay, thank you, Dakota.
Hey, my name is Joseph Zimmerman. I've worked for DOT for almost 4 years now. On June 11th, I was involved in a car accident, as you guys just witnessed. As my supervisor said, it was definitely life-changing. I mean, every day we go out there working on the road, we know the danger, but until it actually happens to you, so you realize how dangerous it actually is. I remember after she got out, she just kept on saying, you know, she had no idea what had happened. It was obvious that she wasn't, that she was under the influence of something. And I remember someone saying, get out of the road or you're going to get hit. And that's when she was throwing the object that they found later on about it. But it's crazy to know that if she was to get pulled over, you know, a mile or two down the road before the accident, that they still won't be able to do anything because, you know, it wasn't on the list. But as my supervisor said, you know, the injuries, still going through it. Hopefully everything goes back to normal one day, but forever thankful that none of us did die that day because of it.
Do you want to add anything else, Mr. Zimmerman, or is that's really it? That you're just glad that it didn't turn out worse, which it certainly could have?
Yeah, absolutely.
Okay, thank you, Mr. Zimmerman.
As I lay there, wondering, who are you? She said it. Who are you? What are you guys doing here? She absolutely had no idea where she was or what had happened, and wondered why we showed up at her accident, basically.
Yeah.
That lives with you forever.
It's crazy that, I mean, she drove by 6 foot tall orange roadwork signs.
Message board.
An arrow board, an attenuator, a pickup truck with yellow LED lights on it, and numerous traffic cones. I mean, she just had no idea. I mean, she had all the multiple warnings to know that we were there and that the left lane was closed.
It appeared from the video that, because the video is taken from the vantage point of the dashboard of the truck that was positioned with the attenuator on it to block anybody from doing exactly what she did. Is that right?
Correct.
and yet she managed to go around it and actually turn into the work zone. Is that your perception of it, or you really don't even know because you weren't
Yeah,
watching?
I mean, she turned right into our work zone. Like, it had been right after she went by the attenuator truck, which is a six-wheeler dump truck.
Yeah, it's supposed to protect you from people like her, is that right?
Correct.
Well, you are speaking to a couple of the sponsors of a bill that would at least work on the fact that she couldn't have been charged. God knows, there's a lot of work to be done in the sphere of vehicular crimes. But we have to start there, that she could be held responsible and held instead of being released, as you guys say. I'm not aware of that, but I wouldn't be aware of that. So I want to thank you, Mr. Zimmerman, like Mr. Hall, like the Carpenters, like Mr. Chowdhury. Yours is the important testimony, and I greatly appreciate you coming here today. I just want to end with this section before I turn it over to the legislators about questions, to tell you that your union did send a strong letter in support of passing this legislation. Josh Terry, who works for Mary Sullivan, sent the letter, and it says, CSEA remains steadfast in their commitment to protecting the workers who keep New York moving. CSEA strongly supports the bill and other common sense solutions that protect workers, drivers, and the traveling public. Together, we can ensure that those who serve our communities do so without fear for their lives. Thank you again. Senator Ryan, Assemblymember Starr, do you have anything you'd like to ask?
Listen, on behalf of myself and the 319,000 people I represent, we're really glad you're alive and you made it. So keep doing what you do, and thank you. And we're gonna try to make some meaningful change. We're gonna try to pass this bill, and people like our DOT workers that show up every single day to go to work. We appreciate what you do, but the most important thing that you do when you show up to work is to make sure that you go home at the end of the day. So every single thing that I can do to ensure that happening, I will. Thank you for testifying, or thank you for being here. We appreciate you.
So guys, thank you so much for taking the time and being with us today. Your story, your stories, your comments are compelling and exactly what needs to be heard, not just by those of us here today, but all of our colleagues when we go back up to Albany and take your story with us. So thank you, and God bless you.
Thank you. We now have to shift to the Los Angeles County Prosecutors. That would be, that would be Garrett, Dameron, and Brittany, Vannoy. They're on one line together.
Actually, we're separated to the south.
Oh, you are? Okay, never mind. Sorry, Garrett.
That's okay. That's okay.
But I'll start by thanking you for making yourself available all the way from California. For those who don't know, California has never had a list. They are able to get blood warrants on misdemeanor DWIs, but I don't want to steal everything you're going to say, Garrett, so I'm going to turn it over to you.
Thank you, and good afternoon. And I'm thankful that I was invited to come here and speak, as this is a very important issue, something we deal with every day here, and I know talking to Maureen is very important there. As Maureen said, my name is Garrett Dameron. I am a Los Angeles County Deputy District Attorney. My colleague on another line who's joining us is Deputy District Attorney Brittany. I am currently the deputy in charge of our driving under the influence, or DUI as it's called in California, special unit known as DTAPS, which is an acronym for DUI Training and Prosecution Section. I've been a supervising attorney in DTAPS for over 6 years. Prior to that, I spent 25 plus years of experience as an LA County Deputy District Attorney in various high-profile trial assignments. The Los Angeles County District Attorney's Office, or LADA, is responsible for prosecuting all felonies in Los Angeles County and misdemeanors for 78 of 88 cities within its jurisdiction, encompassing 4,083 square miles. When fully staffed, there are nearly 1,000 LA deputy district attorneys employed. LA County contains approximately 10.4 million residents living in the area. Within that territory, there are, and the LATA works with over 100 law enforcement agencies. The Los Angeles Police Department and Los Angeles County Sheriff's Department alone have nearly 9,000 and 10,000 sworn personnel respectively. Those two agencies, in addition to the other 100+ law enforcement agencies countywide, demonstrates that there are tens of thousands of sworn law enforcement working in Los Angeles County. Within the LADA, DTAPS is the unit in the office that is responsible for overseeing the filing and prosecution of DWIs and vehicular fatalities. DTAPS trains and assists all LA County deputy DAs on filing and prosecuting these cases from the initial stages all the way through the trial. We consult with members of our office every day on strategies and issues specific to these cases. In addition, we train and assist every Los Angeles County law enforcement agency on the investigation and preparation of these cases for court. We consult with these agencies often shortly after arrests have occurred, or in the cases of some major incidents and fatalities before arrests even occur. We speak with investigators and officers every day about their cases. If there are any issues or problems that are related to DUIs and/or vehicular fatalities, we will hear about them and are frequently asked to consult, whether coming from law enforcement or prosecutors. In addition, we have worked with judges from the Los Angeles County bench on DUI-related issues that impact courts, and we are known by much of the defense bar in LA County and have been consulted about DUI or vehicular homicide-related questions and issues that impact cases countywide. It is important to know that DTAPS is funded entirely by the state of California through the federal government. We are grant funded by the California Office of Traffic Safety through the National Highway Traffic Safety Administration. As such, we are bound by federal and state mandates. In order to be able to receive our grant funding every year, the Los Angeles County Board of Supervisors must approve our award. The Board of Supervisors is a group of 5 independently elected officials who represent the entire population of LA County. The Board of Supervisors has oversight over the Los Angeles County District Attorney's Office, including DTAPS, and supervises and reviews the activities of the LADA, including, if need be, calling on our office to address matters of public concern. The DUI laws in California allow law enforcement officers to stop, investigate, and make an arrest if a driver was under the influence of alcohol or drugs or a combination. The definition of under the influence means, in California, that your mental and or physical abilities were impaired to the point you could not operate a motor vehicle with the same care and caution as someone not under the influence. California does not have a list of qualifying substances that are required to be present and the cause of impairment. Per statute, codified all the way back in 1971, a drug is a substance or a combination of substances that could so affect the nervous system, brain, or muscles that would appreciably impair the ability to drive as an ordinary cautious person would. The impairment must be appreciable, meaning noticeable lessening of faculties. It applies to illegal drugs, prescription drugs, over-the-counter medications, or addiction. Typically, what we see in our quote-unquote run-of-the-mill DUI drug or drug and alcohol combination cases is a law enforcement officer will observe suspicious driving, or the officer will respond to the scene of the crash. The officer, while hopefully a drug recognition expert, although we suffer from a serious lack in numbers of DRAs in LA County, the officer will contact the driver and have a brief interaction while watching the driver for objective signs and symptoms of someone who may be under the influence. If the driving, in combination with the officer's observations, had given the officer reasonable suspicion that the driver may be under the influence, the officer will have the driver perform a series of field sobriety tests. At the conclusion of those tests, the officer will either have or won't have probable cause to the arrest of the individual for DUI. At that point, if based on the officer's training and experience, the the officer either believes it is drug-related or drug and alcohol combined, the officer will ask if the driver would be willing to provide a blood sample. If the driver is unable or unwilling to consent to provide a blood sample, the officer will obtain a judicially signed warrant, as our law allows, to obtain the blood. The blood is collected and tested at a lab for empirical substance. Although not ideal and much less likely to be able to successfully prosecute the case, we do have some drug and alcohol-related DUI cases in our office in which the blood was unable to be obtained or the blood was tested and no impairing substance was found. There are many specific reasons. Our main lab in the county is limited in the number of drugs its devices will detect. In addition, we have seen a dramatic rise in synthetic drugs and the manipulation of compounds and impairing substances, so much so that our drug testing capabilities frequently lag behind emerging drug trends. Furthermore, unlike alcohol and 0.08% of blood alcohol content, there is no per se numbers for any drug. Drugs affect different people differently, and there is no correlation between a particular quantity and impairment. A smaller number in the blood result is not indicative of someone not being under the influence, and a large number in the blood result is not indicative of somebody being under the influence. Many drugs rapidly dissipate from the blood, so much so that if the blood isn't drawn close in time to the driving, the impairing substance will be gone. Nevertheless, positive blood results are an extremely important tool to corroborate the testimony of a drug recognition expert. But an overly narrow list or definition of a drug would hamstring law enforcement's ability to remove many drug-impaired drivers from the road, prevent judges from imposing educational consequences on these drivers, and significantly endanger all those on California roads. Our grant requires us to conduct an annual count of DUI cases presented and actually filed every year. Those numbers are compiled every year in January. In 2024 alone, last time those numbers were compiled, the LA DA's office filed over 10,000 driving under the influence cases within Los Angeles County. Keep in mind, this does not include numbers for any of the unincorporated cities that file and handle their own misdemeanors, including the city of Los Angeles, which has the Los Angeles City Attorney's Office to handle its misdemeanors. That same year, nearly 2,000 of those cases were presented to my office and the City Attorney's Office for filing consideration for drug-related driving under the influence. With all that background in mind, as I sit before you today, I can confidently state that I have not seen or heard of cases, nor seen any evidence in our driving under the influence cases of officers taking advantage of these laws and using them to disparately treat members of any community or group. In my current position, I am confident that such behavioral allegations levied against officers or a particular agency or agencies would have been brought to my attention, either through prosecutors in my office or the agencies and hundreds of law enforcement officers we work closely with. In addition, our relationship with the bench and with the defense bar would have most likely lent itself to my unit being consulted or notified of such allegation. I have a very close working relationship with my counterparts in the Los Angeles City Attorney's Office and the Orange County District Attorney's Office. They have the same or similar roles in their office as I do mine. I have consulted with them, and they too confirm that they have not had to confront this issue. We have safeguards in place that would address and prevent this type of potential abuse. Defense attorneys have the ability to file motions to dismiss or constitutional challenges for this type of behavior. Again, these motions filed in LADA cases would have found their way to my unit, and again, I have seen no such motions. We are fortunate almost all of our law enforcement agencies operating in the county have body cams issued to officers. This allows attorneys in my office to see whether an arresting officer's opinions are corroborated. This tool provides an excellent check on many of the misuse of these laws. The Board of Supervisors, who I've mentioned before, routinely deal with matters of public interest, media attention, and take lengthy public comment during their monthly public meetings, have not been complained for this issue. If they have, I am certain they will call my office and myself as supervisor of this unit to publicly comment. The theoretical possibility of an officer arresting a driver for being impaired by an everyday substance, like coffee, energy drinks, chocolate, nicotine, is simply unrealistic. Not only because we do not see it out here in Los Angeles, but because the safeguards we discussed are in place Whether through defense motions and or public or governmental oversight, it is nearly impossible to engage in such actions. The law prohibiting this type of driving is not slight impairment. It's not any impairment. It's impairment that must be to the degree that they are no longer able to safely operate and drive a motor vehicle and are thus putting innocent lives at risk. It's theoretical possibilities versus reality. The reality is that drug-impaired driving is on a steep rise and is a serious risk to public safety. The misuse of these laws is simply not happening here in Los Angeles. That concludes my comments. I'm happy to answer any questions or Ms. Vannoy.
First of all, thank you. Thanks so much for being with us, and thank you for sharing your experiences. You had mentioned that there's been no negative commentary on the part of whether it's the district attorney's office or law enforcement or bar association or official organizations. You haven't had any outreach efforts by board of supervisors. Are you aware if there are any contentions about those types of potential problems from outside advocacy groups, other types of organizations that tend to become involved in I guess, the criminal justice space?
Nothing. I've heard of nothing from any group, from any agency. I've heard of nothing. As I indicated to you and explained the laws that are the laws of California, I work because of my grant funding in the state. I work closely with multiple DA's offices all out throughout California. We have interaction with law enforcement agencies throughout California, and I can tell you that I have never been approached about this issue being a problem. I know not only here in LA County, because I indicated that the county's close to us, or I work closely with, but also any county in California. I've never had a discussion with or been approached, whether it's coming from prosecutors, law enforcement, any advocacy group, anybody anywhere.
Garrett?
Yes?
Sorry.
I'm sorry, I'm having a hard time hearing you.
Sorry. Just because I spoke to you about this, Garrett, this is Maureen again.
Okay.
I know that you have a board of supervisors, which you and I spoke about, effectively equates to in the city of New York, the 5 borough presidents. And that board of supervisors, advocacy groups are regularly in contact with them, are they not?
Yes, they have monthly meetings that consist of days-long meetings, and a good majority of those meetings are open for public comment when advocacy groups come and speak to the board of supervisors about any issues that they are interested in speaking about, either individually or through groups. That's correct.
And there has been no outreach or outrage by any of those advocacy groups on the part of minority communities, drivers, anybody on this issue?
Not only has there been no comment or outreach about that, but I can tell you every year I'm required to go before the board and the justices of the board members to seek approval of them allowing us to receive a grant. And every year I'm asked questions about various issues in regards to vehicular homicides or DUIs, and not once have I been questioned by any of the board members or their justice deputies about this issue throughout the time that we've been receiving this grant in our office.
Thank you for letting me know.
Garrett, thank you. Just a simple, quick question. You state in your statement that, quote, an overly narrow list or definition of drug or driving would hamstring local law enforcement and significantly endanger all of those on California roads. I guess the question is, so essentially, if you had the same laws that were here in New York, would your California roads be less safe?
Substantially so. I mean, our roads are already, we already see a high degree of DUIs and vehicular fatalities. If we have the current legal setup that we're discussing about that is occurring in your state, we would be virtually hamstrung from not only appropriately apprehending and dealing with the drivers and the substances that we see out here on California roads, but we would also be unable to not only remove those drivers from the road, but to deal with them in terms of them receiving the proper either care or treatment or appropriate punishment, or the victims being given appropriate remedies on their own. We have drug trends that are changing every day. I was on this meeting earlier and I heard mention of nitrous oxide. And I know Brittany has personally handled some very heinous nitrous oxide death cases involving children and babies. And that's an extremely difficult substance to regulate, especially with its limitations in terms of our ability to identify it and obtain evidence relating to it. So to provide a narrow scope of what we could or couldn't test for would essentially eliminate our ability to prosecute a large number of our DUI drug and DUI combination cases.
Thank you for that. Thank you for your time. Thank you for your willingness to provide that information, and thank you for your expertise.
My pleasure.
You're free to go, Garrett. Thank you.
Thank you all very much.
Next, we welcome members of the Coalition to Protect New Yorkers from Drug Driving. Darrin, Grondel, National Alliance to Stop Impaired Driving, Responsibility.org. Senior Vice President, Traffic Safety. Flynn, New York State STOP-DWI Association. Lorraine Martin, National Safety Council of the State.
From the STOP-DWI Association. Are you able to do it? Do you have to leave?
We're good.
Okay, everyone.
Very good, welcome.
Thank you. My goodness, well, thank you so much. It's really, put it down further, thank you. It's really a tough act to follow some of those really incredible speakers, especially the victims, but my name is Flynn. I am with STOP-DWI. I'm in Suffolk County, and I'm representing STOP-DWI New York. And again, it's a pleasure to be here, and thank you for giving me the opportunity to speak. I wanted to say that we are going to be sending some material as well. Some of my counterparts who couldn't be here today, who wanted to add just about some of our work, and this is something we have seen for a long time and are supportive of. But I wrote a little something up, figured I would say it. I became the coordinator for STOP-DWI in Suffolk County about a year ago. I'm proud of what we're doing, as this all is such an important issue. Prior to taking on this role, I was a journalist, and I covered some pretty horrific impaired driving stories from Alaska. I was a reporter there for 2 years, to right here in New York. I was with News 12 New York for 5 years, and unfortunately some of the people in the room I had to see on the worst days of their lives. I want to acknowledge those victims and their families for their courage, bravery, advocacy while facing unimaginable grief. When I explain to people STOP-DWI's position on this drug driving bill, backstory, the question that always comes next is, why would anyone not be for this? Now, I'm not an Albany, but I've heard even today what sounds like people might just not understand. So to explain our stance, which I think is pretty clear cut, I'm taking one of the lessons I learned as a journalist that is most important. We certainly want to see this loophole closed. At the beginning of the symposium, we heard representatives say times are changing and we must adapt. Again, this is something we have seen in STOP-DWI for some time. People are able to get high and drive with things they purchased from CVS. They can change an ingredient while cooking something like meth in their kitchen, and if it's not on that list, they don't get charged. That doesn't mean they're not impaired, but under the current law, if that exact drug is not on the list, then they'll likely not be prosecuted for what they should be, and this must change. Lastly, we support not having the law enforcement need to identify the drug. If you are driving high, impaired, what have you, that is enough. One of the things I love was said earlier, and this was the best layman's terms it was ever explained to me, is if you don't have to identify whether someone's driving on tequila, wine, beer, rum, and someone is under the influence of alcohol, why should this be any different? Again, I thank you and call my questions. Thank you.
Well, good afternoon. My name is Darrin. I'm the Senior Vice President of Traffic Safety for the Foundation for Advancing Alcohol Responsibility and the National Alliance to Stop Impaired Driving. Before I go into my actual formal remarks, the National Safety Council, Lorraine Martin, was not able to attend, but I was asked to just read a couple of things in for the record from their letter, which has been sent to you, Senator Ryan. The National Safety Council strongly supports passage of your amended deadly driving bill. This legislation will save lives and stop traffic violence. It is long overdue. Tragically, a recent report by the state comptroller showed that fatalities and serious injuries have grown significantly in New York since 2019. Behind every statistic is a devastated family from every community across the state. There is no time to waste passing the deadly driving bill and beginning the reversal of the trend. New York State can be a leader in combating impaired driving fatalities. The latest version of the bill is an important step in taking back New York's roads from dangerous drivers. Most importantly, the bill provides for the arrest and prosecution of drivers who are intoxicated by any substance, rather than limiting enforcement to alcohol, cannabis, and the controlled substances in Public Health Law 3306. That concludes just the remarks that I wanted to make for the National Safety Council. Now for the next hour, I have your attention for my remarks.
Senator Ryan has 2 hours.
We can go 90. So thank you very much for your leadership in moving forward on some of this legislation, because we know how important this is and the impacts it has on families, but also the communities. But just kind of by way of background, I served for over 25 years with the Washington State Patrol, retired as a commander in 2017. At the time, before I retired, I was actually appointed by the governor as our Highway Safety Office representative. So I ran our State Highway Safety Office, ran all the National Highway Traffic Safety Administration grants through our office. So some of the work that you've heard from the Office of Traffic Safety from California, Mary Tanner-Richter, who was here, I was kind of her counterpart in Washington. So I actually served under 2 different governors in that role, Governor Brevard and Governor Jay Inslee. And so being able to see kind of how, not only from the law enforcement perspective, but also from legislative aspects and from the funding, and how do we actually make these programs work? How do we address the problems that we're seeing? So as I kind of walk through some of these remarks, I hope that we can actually see some support for 2026. You know, I led a lot of the national, or a lot of our state's efforts to address drug and multiple substance impaired driving. We're very similar to California. We are able to address all impairing substances. Our statute was driving under the influence of intoxicating liquor and or drugs. So that intoxicating piece that I think that's in the legislation actually incorporates not only alcohol, but also the drug aspect as well. And I also was leading our charge against multi-substance impaired driving, primarily, especially after being one of the first states to legalize recreational cannabis. We had medical cannabis in 1998, and really we had recreational since '98 because there was no physician registry, there was no patient registry. We got these cards on the side of the road that looked like DOS printed cards that were saying this is our marijuana medical cards. So we had to deal with a lot of those issues. And then when I came over to responsibility.org in 2020, we helped to form the National Alliance to Stop Impaired Driving, with the whole focus of how do we help states prioritize the multi-substance impaired driver. Not only from an enforcement aspect, but then also toxicology, prosecution, then screening, assessments, and referrals to treatment. Because there were so many different ways of addressing that. Because there's not one silver bullet that's going to solve all of the issues. You've got a multitude of those issues in the system. You know, I would just share, when I was 10 years old, I was sitting in an intersection turning left with my dad. And it's a two-way highway, both go to both directions. And the lane coming towards us is downhill. You can get quite an acceleration coming down the hill. My dad made an interesting comment that was made by, I think, Assemblyman Brown earlier. But he says, I wonder how many people have to die in this intersection before they put a left turn lane in. Why do we legislate my body bag? And so that was kind of part of my, at the time I had no idea what he was talking about. And then later on, when I started growing up, got into my position with patrol, I started seeing why is it that we have to have so much data and so many tragedies to find that may change? Why can we not be more proactive in those efforts and not so reactive? So just a piece and a plea of what the New York legislature is seeing, and as we've seen for almost the last 18 years, why hasn't this changed? And what is the barriers? Drunk and drug driving is an ongoing epidemic, as we know. It claims far too many lives across the United States, and New York is no exception. In New York, 325 individuals lost their lives due to an alcohol-impaired driver in 2023. We really don't even know what the data is for a drug driver, because we don't really have that good data. We don't collect it in those different places. While this is below the COVID level highs in 2021, it is 27% increase in fatalities since 2019. Research from the National Transportation Safety Board, featuring New York, and research conducted by the National Highway Traffic Safety Administration show many of these alcohol-impaired drivers had multiple drugs in their system, and even more of these alcohol-impaired drivers. There's a few jurisdictions that we've kind of done some little tests with from the drugs that they have found when it was only like a 0.08 or a 0.10. They didn't do any further testing because it's like, we have enough to prosecute. What a terrible thought process. We need the full picture. But part of that is that some of them were in the 60s and 70% of those samples where they only tested for alcohol, they had multiple other impairing substances on board. So we need to see that. How do we actually help somebody understand what the community is dealing with if we're not capturing that data and addressing it? NHTSA research examining seriously injured drivers admitted to selected level 1 trauma centers found almost 25% of admitted road users tested positive for cannabinoids, followed by almost 23% or 22% who tested positive for alcohol. Nearly 1 in 5 admitted road users had multiple impairing substances in their system. Now these substances or these statistics are a glaring red flag that something is not working and something must be done to improve existing laws regarding impaired and drug driving. New York State can and should be doing more to combat these troubling statistics and be more in line with the rest of the country in addressing impaired drivers. As we know, these are not just numbers, they're friends and colleagues, they're so many others, people that we've had. Each of us have our own stories that deals with. New York used to be a leader in fighting impaired driving and has fallen significantly behind. The bills introduced in the 2026 session to reform New York's existing drug driving laws in several significant ways. First, it broadened the scope of drug driving to include all impairing substances rather than just on a predefined public health list. Eliminate, we bring up the list, we've said that a lot about this today, but how many of the controlled substances that we arrest people for and prosecute them are on the list? They're not. It's any controlled substance, anything that's in violation, so why do we do that? Alcohol has been mentioned. Why do we have to specify a particular drug? First, rather than just let's eliminate a dangerous loophole where some impaired drivers cannot be arrested or be held accountable. If passed, intoxication will not be limited to just alcohol for impaired drivers. New York is only one of 4 states, as we've all heard. Some New York jurisdictions even require the officers are required to name the impairing substance in order to prosecute. And some New York jurisdictions even require law enforcement to name the drug prior to arrest. And without an admission, any of that, there isn't a doctor in this universe that can actually do a self-evaluation and tell you exactly what drug that is. So why do we have that requirement for our law enforcement officers to do that? That's impossible. It's almost a failure of the system. We cannot do that. As brilliant as the law enforcement officers are, that is just not something that we're trained to, I guess. There is no medical professional who can do that. National labs can see an average of up to 7 to 8 impairing substances in drug screens. And because of this, even the state of Oregon, where I was in Washington, Oregon was a lot more liberal than we were, removed that obstructive and almost antiquated requirement of the list in 2023. In New York, if a motorist refuses a chemical test of the blood or the officer is unable to determine through the investigation the substance causing the impairment, the case can't go forward. The catch-22 here is that New York requires law enforcement to name the drug to bring the case, but allows a driver to refuse the test and doesn't allow a warrant for blood for misdemeanor cases. In addition, even if a motorist consents to a chemical test, if the impairing substance is not on the New York Public Law 3306, the motorist can't be arrested. There are countless substances that can impair. As we heard today, over 400 different substances a year. You can even, in some cases, just change an analog and you change that, or create some of these different isomers that you're seeing with cannabis. And some will say, well, it's not as impairing as Delta 9. The fact is it's still impairing. And how do we know what that impairment level is? The law should simply apply to driving while the influence of anything that makes a person unsafe. Impaired is impaired is impaired. Doesn't matter if it's a prescription medication, an over-the-counter, it is still impairing. Being on a list has nothing to do with a substance that can do to the condition of the driver. We take no position, our organization, on cannabis legalization, and the legalization or the legislation covers the threats posed by any impairing substances. Cannabis is just one of the substances that can impair someone's ability to safely operate a motor vehicle. It has been illegal to drive while impaired by cannabis since 1966. Nothing has changed. And this will only allow more accountability. It won't change anything with some of those things. There must be actual impairment for an arrest, but contrary to rumors, the legislation does not expand law enforcement's ability to make car stops. The bill is limited to addressing how drug driving arrests process the stop. Responsibility.org also urges members to add clear definitions to the New York vehicle and traffic law to define intoxication and impairment. If alcohol intoxication is set by per se or 08, and there are hundreds of years of science to back up alcohol intoxicate per se limits. There's no equivalent per se for drug driving. Though in my own home state, Washington State, they tried to put that in a public initiative of 5 nanograms. But what about those that are clearly impaired and they're less than 5 nanograms? So it is clear that there needs to be more to be done. But since 1910, intoxication could also be established by the observation of a driver's condition by law enforcement or even civilians without a blood alcohol concentration. It is time for the definition of intoxicants to apply to more than just alcohol. The new definition should specify that a driver can be intoxicated by any substance or combination of substances. You saw the definitions of intoxication earlier. I'm not going to reread that part. New York should employ roadside technology such as oral fluid testing. It's been mentioned several times today as a roadside screening tool. The National Alliance to Stop Impaired Driving has compiled a state map to show all states where they're at with legislation. So looking at some of the legislation, some of the model policies, and then what states are actually doing. Alabama has actually incorporated oral fluid not only as a roadside screener, but also evidentiary, and they've also put it into their implied consent warnings. So I know that might be heresy in some areas, but they have done that, and they're seeing some huge impacts of that. Indiana is another great state that we're seeing with oral fluid, Michigan, and many, many others. I think we have some devices here in New York that are operating as well. It has been found to be accurate for purposes of preliminary roadside testing to assist with probable cause of impairment. We have 23 states that have some form of oral fluid statutory authorization. Others are doing some pilot testing at this time. We have implied consent, we have preliminary testing, we have evidentiary testing, and also pilot. So there's a real difference between the devices that are used roadside and then pieces for an evidentiary test. We saw in Indiana where in 2020 they rolled out the oral fluid, and they saw a significant uptick in submissions of blood to the toxicology lab, and also it saw a significant increase in the number of DRE evaluations because officers felt they got something here on the roadside, it's developed a public cause, and now they have a greater reason to than calling out the DREs. And that was a 55% increase that they saw in DRE evaluations. It mirrors the substances that are active. It's not going to get something that was 3, 4, 5, 6 days ago. It's just the active and what's actually leading to the impairment. It's not going to prove impairment because presence doesn't mean, it doesn't mean presence doesn't mean that they're impaired. It just means they can start seeing what they're seeing roadside. Statutory authority backing this technology will make our roads safer, will create a deterrent effect on motorists, and will support use by law enforcement to assist with building probable cause. These devices are used after the officer has completed the field sobriety test, not before, but after. We should be able to substantiate some of that impairment with the driving, with personal contact, the field sobriety test, and that. While DREs are currently the best method to detect actual impairment, sadly there's just only a tiny fraction of total law enforcement officers. In this state here, I think you said you had 420 DREs. I think one of the counties that we were looking at, Suffolk, had 24. But how many of those are on duty, not on duty? How many do we have that are then being promoted and then are not able to come back and fulfill those responsibilities? So it is a very difficult process to maintain, and keeping a high level of those. Roadside testing has multiple ancillary benefits to the state in addition to removing impaired drivers from the roadways. More complete testing, in addition to alcohol, provides the state with a clear picture of the state's drug driving problem and allows the state to more efficiently direct limited resources. In addition, complete testing provides prosecutors, judges, and treatment professionals with a more complete picture of the substances causing impairment to inform sentencing decisions, but more importantly, to inform treatment professionals who will now be able to treat and cure the underlying addictions to prevent recidivism. It was mentioned earlier is not only is it we're saving lives on the road, but can we actually save lives? People that come in as a DRE or as a DUI, that there's an intersect point, that we're seeing these pieces where we can actually see, yes, drugs are on board, they have a mental health and a substance use disorder or co-occurring disorders, and how do we actually address that? That can improve communities, and they're not only involved in DUI crashes. It could be domestic violence, it could be child abuse, and other types of crimes that now these types of devices can see. We can get the treatment that they need and actually see more of a quality of life. Well, New York currently suspends licenses pending prosecution for drunk driving cases with a BAC of a 0 or above. Drug driving violators can currently be arraigned and leave court with a valid license until the case is adjudicated. New York should suspend both alcohol intoxicated and drug drivers' licenses when there is a test result of admission. I would just say too that it's almost like a failure to act actually tells the New York citizens that it's okay and almost acceptable to drive with drugs in their system. We know it's not. But what is the message that the community is actually getting? I just wanted to say thank you to both of you for the leadership in both the Assembly and the Senate. Hopefully this can be a nonpartisan issue. This really should be a nonpartisan issue and really should be able to move forward unabated. But I also wanted to say thank you to Darrin, who's been a tireless advocate in this process. For her, sometimes she feels like she has to wear asbestos underwear because it gets hot. And but truly is that she has been, I don't think we can find a much stronger or better advocate for that. I've been in this business for over 33 years. I've done next of kin notifications. I've seen families, like you said, at their worst. And we have a huge problem in this country. 42,000 people lose their lives every year in traffic crashes. And traditionally, what we've seen, doesn't matter if it's 42, 29, 1/3 of those are alcohol-involved fatalities. We don't know what it is for drunk driving. We know it would only be even greater. Responsibility thanks you for your time and attention to the issues addressed in this testimony and the considerations in making a policy decision that will positively impact people's lives. And I'm happy to share any additional information and address any questions.
Thank you.
Thank you. Being from the Northwest and experience that you've had in a couple different capacities, which is very impressive. I'm grateful for your insight. Oregon just passed their law in 2023. I'm wondering if there's anything that, well, first of all, did you have the opportunity to follow that closely? Did you see or have an appreciation for how that all went, why that all went, the time that it took, and what Oregon's legislative experience might have been to be able to share any insight and any help in getting our version, our New York State initiative over the finish line? We're always looking to the experience of other jurisdictions and wondering if it's something that we should. So in Oregon, the challenge that they had obviously was they legalized everything. And so, and I think they've actually rolled pieces of that back now because they saw the impacts. The traffic safety resource prosecutor there, Ryerson, really was a strong advocate for getting this done because they were always having problems. They were not a blood state. They were strictly urine for DUI cases, which is a terrible matrix for DUI cases, by the way. Am I right? Yes. Thank you.
Bad.
Bad.
Very bad.
So they actually incorporated blood into that piece as well, so they can actually look at prosecuting cases where the person is impaired. Now, you might even lose cases where they say, well, we're not going to admit the toxicology report. The officer should be able to clearly articulate what is that impairment absent a chemical test. And that's what we would say at roadside. So the Oregon, which was very liberal, legalized everything, you're in a state, being able to then change that was very significant because DUI cases or DUI legislation was very difficult. When they did legalize cannabis or recreational cannabis, I was part of the working group with their governor's DUI task force. And one of the things that we shared with them is don't put a per se limit in. Because there's no empirical evidence to show what a 5 nanogram really means. And so they left that open, which was very surprising. So, but the actual piece of the list, being able to get rid of that and then adding just all intoxicating or all impairing substances was significant, especially for those that are up in the Northwest, where it's very liberal and they don't want government intrusion. But they saw the impacts that drug driving was having, and that's why they actually made those significant changes to the legislation. Thank you.
Thank you very much. There's a lot of information and good information, so thank you. And thank you for your advocacy. My question is, beyond all that good statistical data, my question is, how is it that, and spoiler alert, because the same question is coming for the next group, how do we all work together? And just not for now, or kind of something that we need to start thinking about as we approach the next legislative session. Your advocacy group, yours, the next panel, how do we work together to expand this conversation? And I think that's what I guess I would like to hear that, but then my offer is what more can we do? How can we take the conversation a little bit more broadly within the New York State legislature? Obviously, we're here because you know where it's been. There's a lot of bipartisanship on my bill. And I just will look forward to really working together next year because, again, this word, I'm going to use it again, and I have to again, formidable. We are much more formidable when there's more of us working together. So, I mean, that's your story and your data. It's great. I just would like to make sure that some of my colleagues hear that so that we can, because quite frankly, I think that that's part of what it's really going to do to get this over the finish line. So think about how can we expand the narrative? How do we expand conversations? How do we work together? And we'll talk more as we get into next year.
I mean, I think for one, we gotta communicate better. I don't know if it's possible, but maybe everyone that was at this today, clearly there there's so much passion, there's a lot of experience, whether it be firsthand or in a courtroom or wherever. So I don't know if you get everyone's email from today, but just continuing the conversation and getting some of these people to Albany. And, you know, for me, again, going from that journalistic background, but also what I've just seen in this role, I don't think there's anything more important than hearing from a victim or a victim's family and how it's impacted them. And we can hear statistics all we want, but when you hear about how someone's life was changed by something like this, and you can relate to it, whether it be you think of your brother or your grandparent or whoever. I mean, most of the time I'm watching these videos today, I was thinking, my gosh, I've been on that road. Why did that happen to me? I think that drives it home more than anything. And I just want to say too, STOP-DWI, you know, this was something that came out of, we saw a problem with drinking and driving. This was in the late 70s, early 80s, and we changed it. We were at the front here. I actually was also a reporter in Washington State. I've never seen anything like STOP-DWI, where every county has a representative looking to do just that. And I'm excited to be here today because I feel like we have the opportunity to do something really impactful again and make our roads even safer.
Yeah. I think, you know, for our organization, we're a 501c4, so we're in a lot. So we actually can come in and actually help support any of that. But we're more than just our organization. The coalition that's been built here in New York, as I mentioned earlier, there's over 50 plus different organizations. I think bringing together that energy of the coalition, being able to have meetings with individuals and we think, you know, how can we get this message to them? And we've got the videos and all the information, but how do we have those one-on-one conversations and address any of the concerns that they might have? How do we get more of their own constituents actually more involved in supporting this legislation? Because this is impacting everybody. And so I think those pieces, high school students, when I was a highway safety office director, we were trying to pass legislation, we had high schools galore, leadership groups that would come in and testify. Hospitals, because the hospitals themselves are seeing the victims that are coming in and dealing with that, and they see the tragedies. So being able to bring in all these different groups and really flood the field is, I think, going to be very important, and we have that ability to work with that. With not only letters, but also phone calls, we can do personal visits, and those kind of things. So that's what we're geared up to do. So anything we can do, because this means a lot to everybody.
Thank you, guys.
Thank you.